I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are at exit 230 on our compilation list. That's right, we are at number 230, and today we will be in two different judges' courtrooms for this compilation. Before I give you those names, as always, don't forget to like, comment, share, and subscribe. Commentary will be left in if these proceedings had commentary in the past. Also, chapters will be added for your convenience. Now, the two judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge William Baylor Guillen out of the state of Michigan. And for our second proceeding, we will be in the courtroom of Judge Jeff Kahn out of the state of Colorado. As always, it is a pleasure to bring you these compilations. And it is now about that time to jump into 230.
I keep getting hung up on no cell service and I'm using Wi-Fi.
Mhm.
Can you hear me now?
Yes, now we can hear you. Very good. All right, state your name for the record.
My name is Fernando Gonzalez, living man.
Very good.
I'm here
And we already have
representing my
appearance of
corporate
Mr.
fiction of the
Duffield
exact same name.
in regard to the matter for motion to dismiss,
Did you hear me,
Mr.
Your Honor?
Gonzalez.
Your Honor.
I did hear you identify yourself as Fernando Gonzalez. Thank you. Please proceed with your motion for
Yes.
dismissal.
I'm here representing my corporate fiction of the same name. And I'm here to motion.
Well, you're here
I'm
as
here to.
No, you're here as Fernando Gonzalez. Because
Right,
if you're
but
not
I'm
here
not-
as Fernando Gonzalez, I will have to issue a bench warrant for Fernando Gonzalez.
You and I both know I'm representing my corporate fiction, the all caps name.
You cannot do that. You cannot represent a party other than yourself, sir.
Well, then we got a problem.
You
under this part,
and
challenge
I
jurisdiction.
both know that. So
No,
proceeding
that's
as
not true.
Fernando Gonzalez,
If
do
I
you
own
wish
a
to
name-
address your motion first? Do you wish
If
to
I-
address your motion for dismissal?
Yeah, I would like to challenge
Please do
jurisdiction
so.
like you didn't. I'm here by special appearance to challenge jurisdiction and motion to dismiss for lack of jurisdiction. I mean, I've all but trademarked my corporate fiction name. You know, we're going to just have to do this again in 6 months once it's trademarked.
Well, that's not true. Your motion is dismissed and denied because it is not based on any actual recognized legal basis. So in regard to the trial,
I object to that.
Okay,
I
that's
object to
fine.
that
You can
strongly.
object. And upon receipt of your judgment, you can go ahead and file an appeal on that if you so choose, but we are proceeding. Mr. Duffield.
Thank you. I would call Deputy Louise Hempston to the stand. Your Honor, would you like me to approach the podium or may I stay at the table through the duration of questioning?
You can remain.
Just have a copy of my.
You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Have a seat, state your name, spell it for the record.
Louise Hempston, Hempston.
Very good. Please proceed.
Thank you. Deputy Hempston, where are you currently employed?
Allen County Sheriff's Office.
How long have you been employed at that location? Or with that employer?
Almost 5 years.
All right, and what are your job duties entail?
Road patrol for the Sheriff's Office.
Do you recall making a traffic stop with Mr. Fernando Gonzalez? I believe it was June of 2022.
Yes, June 26, 2020.
And do you know where this traffic stop was located?
It was on the northbound 131 on the 66-mile marker. It would have been in the Wayland Lake Township. Allen County.
And what was the nature of the stop? Why did you initiate a stop?
I observed a vehicle traveling in front of me. It was going northbound. I was also going northbound. The vehicle did not have a license plate registration attached to it. I could see.
And so you initiated a traffic stop at that point?
Yes, sir.
Did you make contact with the driver of the vehicle?
Yes, sir.
Did you ask the driver for their license and registration?
Yes, I did.
Did the driver provide you such documentation?
He
I gotta
told me he didn't
object,
have those
Your Honor.
items. And that's he.
What is your objection?
He's labeling me a driver when he has no proof that I was transporting goods, services, or passengers for hire.
Your objection's overruled. Please proceed.
Thank you. Again, did he provide any, the documentation, that you requested?
When I asked for them, he said that he did not have them, and then he told me he wasn't driving, he was traveling.
Do you recall what type of vehicle, the individual was in?
It was a silver Ford, I believe it was a Focus.
And to your knowledge, is that a motor vehicle?
Yes, sir.
Were you able to identify, the driver in some capacity or in some way?
Yes, I was. There was some legal documents. The driver would not identify himself, and I attempted to look at the VIN plate on the front dashboard underneath the front windshield, which is obscured by some paperwork. That paperwork for legal documents and identified a person's name, and it also identified an address. I used that address and that name using lean to come up with a name and a picture that identified the same person as was driving the vehicle.
And did you, when that was pulled up in your law enforcement information network, did that include information on whether the individual had a valid driver's license?
Send operator status was denied, suspended. So
Did you inform the operator of the vehicle about this?
yes,
All right, and then was the individual whose name you read and who law enforcement information network provided you the information, was that individual Fernando Gonzalez?
yes.
Your Honor, does the defendant have the, at this point, I would ask if the defendant had the capability to turn on his video camera so that the witness would be able to verify whether the person present is or is not that individual?
Mr. Gonzalez, turn on your camera, please.
Is it on? Can you see me?
No, you have it turned off, actually.
Well, it says it's on my end, but I don't see myself.
But you probably,
How's
there
that?
you go. There you go.
If
Yep.
if you were to see this individual again, would you be able to recognize him?
Yes.
All right, do you see that, if you see that person in the courtroom or on
Can I
Zoom?
speak up?
If you were to see that person in the courtroom or on Zoom, please identify them and point out
Yes.
something that they were.
Fernando Gonzalez on the Zoom screen.
Mr. Gonzalez, thank you for turning your camera on. If you don't wish to keep it on, that's fine. I don't have a problem with that, but I usually like to be looking at the person I'm dealing with in court, but I do need you to take your hat off because we are in court.
I'll take my hat off for $500.
Well, then
We're-
you can either take your hat off or be held in contempt of court, or you can turn your camera off, one or the other.
I'll turn my camera off. I don't like being told what to do.
Okay, very good.
May the record reflect that.
He did identify, yes.
And so you said that this traffic stop occurred northbound US 131 near the 66-mile marker?
Yes, sir.
To your knowledge, is that within the borders of Allegan County
Yes, sir.
in the state of Michigan?
Yes, sir.
And US 131, is that a limited access highway?
Yes, it is.
All right, at this point, Your Honor, I would ask to move to admit the People's Marked Exhibit 1 under MCL 257.204A, given that it is a record kept by the Secretary of State in compliance with that statute, and is a certified copy of such, if I may approach.
You may.
For the record, I would state that I emailed a copy of this document to the defendant at the email address I had on file approximately 25 minutes prior to the start of the trial time.
All right. Any objection to the exhibit, Mr. Gonzalez? No objection, it's admitted. Anything further?
Your Honor, I have no further questions for this witness at this point. Thank you.
Mr. Gonzalez, do you have any questions? Mr. Gonzalez appears not to have any questions. He's muted himself, so you may step down.
Sorry about that. Yeah, I do have a question.
All right.
How did we get this far without establishing jurisdiction?
jurisdiction is established by the Michigan Constitution. And
Did you get the
this is a
paperwork that
duly
I sent?
recognized court of the state. I've already ruled on that motion, sir. If you wish to address it on appeal, you're welcome to do so. We do have a jurisdiction. Any further questions
you
of
don't
this
have jurisdiction.
witness? Of this witness, do you have any questions of the witness?
Of this witness, no, I don't think I do, other than
All right,
who's
you may step down.
the injured party here? I mean, I would like to cross-examine the injured party, not the police officer that wrote the ticket.
Okay, very good. Anything else you'd like to present, Mr. Gonzalez?
I would like to present the documents that I emailed you earlier with.
We've already
my
established your
FOIA
motion
request.
for dismissal has been denied.
What
If
about
you
the
wish to
other
address
stuff
that on
that-
appeal, if you wish to address that on appeal, you're welcome to do so. I did receive your lien notice. I have no idea what that is supposed to mean. So anything
Well,
else you'd like to present to the court?
Which question did you have on the document?
I don't have any questions on it.
Well,
It
if
is
you don't
meaningless
know
to
what
me.
that document is, then maybe we should.
Well, the document,
pause for a minute
sir,
and
the
figure it
reason,
out, because
well,
You're
I can
fishing
tell
for
you this,
jurisdiction when you don't
sir.
have any,
sir,
and
sir.
Your
The
Honor,
document,
we can't
the
proceed.
document.
We can't proceed without jurisdiction.
All right, I have an
Thank you.
idea, sir. You don't interrupt me and I'll try not to interrupt you. So go ahead and make, if you've indicated that you didn't have any questions, and that's fine. I told you the reason that in regard to that, the notice of lien you sent, it's a meaningless document from a legal point of view. All right? Anything
Okay.
else you'd
I
like to
don't agree.
establish on the record?
Yeah, what about my
Okay,
FOIA
he has
request?
nothing further. You wish
Yes,
to
I
sum
do.
up any arguments you have?
I object.
Mr. Duffield.
You're not letting me proceed. You're not letting me defend
Sir,
myself.
you're not proceeding. You keep saying you want a motion for dismissal, but I've
I
already
didn't say that.
directed that
I mean, I
that is
said it was.
denied.
But I asked you, did you read the FOIA request that I just sent you a while back?
Sir, no, I did not read a FOIA request because I haven't received one. So I can
I
tell you,
sent one.
and not only that, that would be irrelevant to this proceeding.
How would
In
you
any
know
event.
without
So,
reading it
Mr.
first?
Anything further?
How would you know without reading it first?
Because a FOIA request in regard to this matter, we are talking about a motion, a trial for driving with license suspended. Do you have anything pertinent to that in regard to this trial?
Yeah, the FOIA request that I sent you. Pretty
Okay,
much takes
anything
me out
other
of
than
your
that?
jurisdiction.
Sir, I am deeming that to be irrelevant. You can take that
Without
up on
reading it
appeal as
first?
well. You
Without
can take
reading
that
it
up on
first,
appeal
really?
as well. Well,
So
sir, we're on you don't file things a moment before a trial and then expect the court to receive it. First of all, we didn't receive it, but in any event, sir, I've already
Well, I
made my
never
ruling.
even-
Do you
I
have,
never
sir,
can-
I'm not going to argue with you. The matter is that is disposed of. You can address it on
That's
appeal.
why we're here
Anything-
today, is to argue. Now,
Sir,
listen to me,
sir, you can
Your
address it on appeal.
Your
You can
Honor.
address it on appeal, sir.
You want to get out of this so bad, you don't even want to fight with me on this, or what? You're
I
just
don't want to
gonna
fight
ignore
with
me?
you at all because that's nonsense. I don't want to fight with you. I have nothing against you, sir. I'm just asking you to proceed with pertinent information.
Well, how would you know if something's pertinent if you don't look
Okay,
at it?
that's enough. All right, any arguments in summation, Mr. Duffield?
Your Honor, my office's obligation is to prove the elements of this crime, each one beyond a reasonable doubt. The elements being that first, that the defendant operated a motor vehicle, which is defined under MCL 25733 as a vehicle that is self-propelled. I believe based on the testimony that the vehicle at issue in this case meets such a definition. Second, that the defendant was the one who operated that vehicle on a highway, US 131 being the limited access freeway with a 66-mile marker. I believe we have.
I object.
Is the only testimony in evidence compels that conclusion. And third, that at the time that the defendants, at the time of the travel or of the driving, the defendant's operator's license was suspended or revoked. We've heard testimony from the deputy. She cross-checked using the law enforcement information network, which showed that the defendant had a suspended or revoked license. Further, we have since procured a copy of the Secretary of State certified driving record that the Secretary of State maintains by statute, which also shows that it has been suspended. So I believe we've met all of the elements of the crime beyond a reasonable doubt, and I would ask that the court find such. Thank you.
any argument pertinent to the case, Mr. Gonzalez?
Yeah. I thought this case was squashed a long time ago, or else I would have prepared for trial, which I never even consented to last time I challenged jurisdiction. I should get more time to defend myself if this case is going to be going forward without me being able to defend myself. That's not fair. I thought this case was squashed the moment I sent that ticket back with all rights reserved.
Well, that's
With 72
nonsense,
hours,
and, so that is,
you have nothing to
you've
base
known this
that on
case
other
has
than
been
your-
pending. This case has actually been pending since 2022.
That's not my fault.
Here,
I
well,
rescinded
that
that
is
ticket
indeed
in
your,
72
in
hours.
any
So
event.
your guys'
I do find that the people have proven their case
Honoring-
beyond a reasonable doubt. Please, Ms. Card, go ahead and, well, okay, he stopped. I do find that he's guilty in this matter. Fines are $250, state costs $50, court costs $200, crime victim right fee of $75.
You don't have my consent on any of this.
And $150 in bench warrant fees.
And I want my bail back too.
That would be then a total of $725, and I'll give you 90 days to take care of that.
That's
Is there
not gonna
bond?
happen.
Is there actually bond that's been posted? We have $300 bond. We'll apply a bond,
I object to that.
and we're applying it.
For a victimless crime, that's,
And remaining balance of $425 is due within 90 days. We're all set. We're going to mail out the judgment to you, sir. If you wish to appeal, you're welcome to do so.
thanks.
Exhibit, Judge,
I'm sorry?
exhibit.
The exhibit's returned to the prosecutor.
Well, guys, we have come to the end of what ended up actually being a trial for Mr. Fernando Gonzalez. As we can see, he had his super sovereign citizen head on very early. He talked about trademarking his name, a lot of the same lingo, jurisdiction, injured party. I was surprised, though, when the judge asked him to take off his hat, his response of, I'll take it off, if you give me $500. But not only that, but then I was even more shocked by the judge telling him that he can either take it off or cut his camera off. I've never seen any judge since I've been covering any type of court cases, sovereign citizen or not, to tell a defendant that they can keep their camera off during a court proceeding or a trial. So that was very interesting. But as we can see, officer testified. Mr. Gonzalez ended up losing the case, $425 in fees. It is what it is. He kept talking junk. He even said, basically, well, if you think I'm going to pay it, watch this. So who knows what's going to happen with this. But I feel like Judge William definitely did a good job. I think he allowed Mr. Gonzalez to talk a little bit over him, a little too much. But we even see some of the veteran judges, just like recently, Judge Simpson. To me, I was surprised how he allowed Mr. Magoo to talk over him as long as he did. So sometimes judges just allow it to happen. But anyway, Judge William did a great job. This case seems to be over, but if not, we'll be seeing from Mr. Gonzalez again. And I may even go back and see what his earlier proceedings or his earlier appearances were like before Judge William. And if I do find any of that footage, I'll definitely share it with you guys here on the channel. But with that being said, I know I've talked enough. This is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Don't forget to like, comment, share, subscribe, and God bless.
Hi. Still the same old charming self. Okay, good morning. I'm really grateful to see you. You don't even, it's been crazy. I've been looking forward to this moment.
I imagine you are. We've been tracking you as to where you've been, so we knew where you were in Jeffco for a while.
Great.
Yeah.
I was worried. I'm like, why am I not? I tried. Yeah. Anyways, health.
Okay,
Yeah.
you're
I'm
here.
grateful to see you guys.
Okay. So
Ms. Colleen.
I was able to speak with Mr. Cardona. He is inclined to take the plea. However, before he does that, he wanted me to inquire, since he's been in custody since April 3rd, if he would be getting credit from that date.
So Ms. Talene, the credit that he would get would be for the time that he's been in custody in Boulder, not for the time he's been in Jeffco.
And that's only for a day. I think he's only been here for
Yeah.
a day.
So in other words, no.
Okay.
No dice.
So then I think he's probably not going to end up taking that deal. I mean, I will say he still has some other stuff that he's got to figure out. So
I'm time served on the other stuff because it's since they entered a writ on April 10th. So I'm time served on that. And I'd be willing to like negotiate, like, look, I've been through so much. My mom is stealing my dog, which you guys all
Careful with the language. Careful with the language.
You all know that she's mine. And so I had to take a plea, and I'm just so done with all of it. I'm ready to take a plea, whatever. I'm over it. I've just done 122 days of my life for something that I did not do. And so if you guys could help me to help you to help us, I'm definitely down. I'm just not going to sit in here for 45 more days for mostly garbage charges. Like prohibited item. Like, no. I'll bail out and we'll go to trial if we have to, but I would much rather not have to have loose ends, and I would much rather deal with it than have to continue prolonging it. So if we can come to an agreement that's not.
So
gonna-
let me ask.
I can't be part of that discussion. So let's
Yeah,
pause
I was
for a
going to say,
moment.
so let me ask you this, Julio. What if we brought you back next Wednesday and I could speak with Miss Keller about some different options for you?
That would be great. If in the meantime, as I said, I'm time served on my other ones. And so
I mean, you'd be able to bond out still. If you can post your bonds, you'd be able to bond out. But
according to the jail, there's a $50 cash only bond. And since like I was trying to come to court last time, I got arrested 2 days after you signed the release or PR bond on Sunday, the 28th. I would have been here, but I got arrested. So if you would be willing to reinstate that PR bond on that, I'd be grateful. I'm still held on a $2,000 bond until I go to court, but I don't want to be stuck in here. If I post a $2,000 one, which I guess, right, if I post a $2,000 one, I don't want to be held here on a $50 more thing. So if you would be willing to redo what you did on Sunday, March 28th by signing a PR bail and reissuing that, I'd be grateful. I would have been there, but I was in jail and I couldn't be there. If you'd be willing to do that, I'd be grateful. If not, I can probably try to come up with a $50 bond that it's currently $50 cash only.
Is that what they're telling you at the jail? That's the only cash bond that you have to post? The others are PR bonds?
No. So originally when I first got here, before I got here, I was told I had 4 $200 cash or surety bails. Meaning the 10 cent, like basically $80. But then I got here and they're now telling me that there's a $150 cash only for my municipal cases, but no PR bonds. So I basically have to post a $2,000 cash or surety bail and then a $50 cash only bail. I do have my family working on the cash or surety $2,000 bail. But that apparently they didn't do the 10% option or whatever, so they can't just go to touchpaydirect.com and do it like they usually would. My mom's obviously doing the other thing, so the only person I have that is family to help is over 10 hours away and not able to be here. So they're trying to do it online and trying to facilitate to that. But even once they accomplish that, then I'd still be held here on the $50 cash only bail until I could come up with that. It's like, so if just originally on March 26th of this year, I took a plea bargain and then I was still held here to come to your court. And then on Sunday, the 28th, I'm assuming it was you, signed the approval for a PR bail in my municipal cases. And I was released on Sunday, the 28th, and I was arrested again on the 3rd. So it wasn't that I like was trying, when I'm in cuffs, I can't show up. You know what I mean? And I did have my family text Ashley, try to reach out to Ashley and everybody to try to communicate so that you would be aware that I wasn't trying to skip out on you. And that it's been a crazy, crazy few months.
Okay, so let me just have you pause for just a moment, Mr. Cardona, because what Fernanda has been doing while you were speaking was getting me copies of the warrants and the bond amounts that are on those warrants from our court. And so I'm going to share that, what I have. And Fernanda, you can jump in after I've done this. But what I am seeing is in case number 2024-5724, there's a $200 cash bond. In case number 2024-5730, there is a $200 cash bond. In case number 2024-5633, there is a $200 cash bond. And in case number 2023-4906, there is a $200 cash bond. Now, I don't know, I would have to do a little bit more digging because I'm just looking at the face of these bonds. They don't show the charges, so I'd have to go into each one to see if they were eligible for PR. I know that 2023-4906 is not eligible for a PR bond. That's one of the $200 cash bonds. And at this juncture, not today, I'm not willing to convert those to PR bonds. It would maintain those. That one is a cash bond. By statute, there are some that have to be converted to PR bonds when a defendant requests that. So I will be looking at each of those to make sure that I'm complying with the statute, because what defendant has done now is made a formal request for a PR bond. But I know 2023-4906 has a misdemeanor state counterpart, and that one would remain. So we can do this now, or what we can do is hold off, like Ms. Talene was saying, and come back on Wednesday. And in the
then
meantime,
I might be able to talk to Miss Keller and see if we could work out some disposition. I don't know. We may or may not, and then we could deal with the bonds as well. But
okay. Even if we could get them to convert it to the cash or surety 10% thing, I'd be willing to post a bond. I have no problem trying to
so
post
maybe that's what you're thinking, because our cash bonds also come with an alternative of a surety bond. The surety bond is 500. So maybe what you're thinking is that you have to pay 50 to a
50,
surety,
yeah.
and then that's your 10%. But
yeah,
our cash bond right now is 200. A surety bond would be 500 on that case. So that's why you might be thinking all you have to do is come up with 50 to get a surety to do it. But that's not something that I have control over. That's obviously between you and a surety, a bonds person. So
whatever happened to the 10% thing that you guys used to do, to where my dad could just jump on the...
That's not us. That's what I'm saying. That's something that's done with a bonds person. And there may be something where there's an online process. Ms. Talene may know more about that than I do. I've never interacted with the online bond posting process with a surety, but that's a separate person who's doing that, or a company that's giving you, posting the bond on your behalf based on your dad or you giving them a certain percentage of the amount that's owed, and then them being responsible for the rest. That's how the surety bond works. Does that make sense to you, Mr. Cardona?
Yeah, I'm just trying to, because every other time I've bonded out on every single case you're talking about right now, including the one that you say is not PRable, and I've been released on that charge on PR several times. So I'm just confused as to why it's suddenly different.
Well, right now you have a cash bond that I've imposed, and it's because there's been failures to appear. Obviously, that's why I've made it a cash bond and am not converting it to a PR bond. I am going to follow the state law with respect to the ones that you're entitled to have PR bonds, and some charges you are automatic PR bonds. The more serious ones are not. The ones that are less serious, like you mentioned, a tent or a camping charge, those are automatically eligible for PR bond. That's probably why. What you remember most is most of your cases have been eligible for PR bonds because they were automatically eligible for some.
So I mean, like, you released me on those charges, even the ones that you say And again, it wasn't that I didn't appear, it's that I was being held against my will in another county's jail. So
I
if you
understand
could
that.
reconsider that, I'd be grateful, because this,
I'm not going to reconsider it today because I don't think any party has the opportunity to go through all of the circumstances of each of these. And given that Ms. Talene is in the mindset to see you Wednesday, and that you have another case that's pending with the bond for this state, let's reset your case. I'm happy to reset it. And we could even do Monday if you think that's better, Ms. Talene.
Well,
but
the
maybe
only reason that I was asking for not Monday is just because it's Friday and I'm
Right.
actually getting on an airplane in a couple of hours.
Okay.
So, I mean, I'm doing court on Monday, but I'm just saying I don't know if I'm going to have time to actually talk with Miss Keller and look up all the bonds and all of that information by Monday. So that's
And
why I was asking for Wednesday.
if everybody wants to remain on, I'll pause and I'll look through every single one of these cases to see which ones are eligible, but it may take me quite a bit of time to do that.
I would
Your
be
Honor.
grateful, but
I mean, I guess we could bring it back on Monday and I can see what I can do by then. And if I don't have a chance to talk to Miss Keller, it is what it is. Or you can do it now. I mean, either way, I'll defer to the court.
All right, let me just, someone was trying to speak. Who was that? Was it Ms. Keller or Ms. Fernanda?
Excuse me, Your Honor, it was me, Ms. Bittencourt. Mr. Cardona does have a court appearance with Boulder County on the 13th of August, so I believe he's still being held until then.
right, but I have the bail for that. I'm gonna post bail on that, and or also that court date on the 13th. I'm already time served already, according to the
So
deal that they're gonna do on the
let's
13th.
pause and then I'm gonna look through the files, see what I have here. And then it may take me
Thank
a few
you.
minutes because I got to look through each one of them and see which ones are automatic PR bonds and then which ones are not.
I know there's a lot. Thank you very much for working with me, guys.
Okay, I'm going off camera for a moment.
Oh my goodness. Oh, it's still waiting. They're gonna come back. Appreciate you. He said it might take a while because I got like 21 cases he's got to go look at. So.
I have a quick question for Fernanda. Fernanda, the documents that you provided me, are those the only cases where we've issued warrants?
There's one more case, Judge. I can say it to you. Let me know when you're ready.
Go ahead.
235211 GE.
Okay.
That warrant hasn't been cleared yet. The other ones Jefferson County cleared for us.
Okay, thank you for that. I'll look at all. So I think it's really 5 cases that I have to look at then.
That is correct.
Okay, I'll be right back.
I don't know if everybody can still hear me or not, but one thing that I know that I've become aware of that I wasn't prior is 90% of these charges are what's called administrative legislative statutes, which is known as color of the law, and that is illegal to practice. And if it continues forward, I will be giving statutory official notice to everybody of the 1983 federal lawsuit that I will be bringing into the court. If this court does continue forward under administrative legislative statutes, without an verified injured party and under their assumed jurisdiction, I will be suing. And I will give everybody statutory notice of intent to sue both individually and to official capacity as soon as I get out. Or we could just settle it. Seems like it'd be a lot easier for everybody. There must be a verified injured party, and you must prove your jurisdictional means to do these things, none of which have occurred. I am hereby asserting my rights to those things, assuming that everybody can hear me. And it's being recorded, so it's on record regardless. Yeah, it's still going. I'm still waiting. I'll let you know when I'm done. Hey.
Okay, we can go back on the record. And I did hear what defendant had to say with respect to his statutory rights that he believes he has. I'm not going to address those issues with him. That's certainly his right, and he can consult with his own attorney as to how he wants to proceed with respect to that. I'm just here to at this point to address the requests for PR bonds. There are many cases for which we have not issued warrants at all.
Okay.
And then there are 5 cases for which warrants were issued, 4 of which were cleared by the Jefferson County Jail. One, for whatever reason, hasn't yet been cleared, but it will be cleared. Of those 5 cases, case number 2023-4906 is the most serious. It's a threatening bodily injury charge. That has a $200 cash bond or a $500 surety bond currently authorized. It does have a state counterpart. I did note that the defendant had failed to appear more than once. Many times he would call after court and get his case rescheduled, but there were 2 separate failures to appear in that particular case. And one, the most recent, was March 11th of 2025. And then ultimately we allowed PR bonds on those, I believe. But in this case, now that there are cash or surety bonds in place, I'm going to maintain that cash or surety bond on case number 2023-4906. Case number 2024-5724 is an obstructing government operations charge. There's a prohibited items. That's PR bond, but the obstructive government operations is not a mandatory PR bond because it does have a misdemeanor state counterpart. That will remain at a $200 cash bond or a $500 cash or surety bond. Case number 2024-5633. This is an improper care of animals charge, which does have a misdemeanor state counterpart. That will remain at a $200 cash or $500 surety bond. Case number 2024-5730 is an obstructing government operations charge. That does have a misdemeanor state counterpart. That will remain a $200 cash bond or $500 surety bond. And then case number 2023-5211 is an obstructing government operations charge, which has a misdemeanor state counterpart. That will remain as a $200 cash bond or $500 surety bond. All the other cases we have not issued warrants for, so that I'm not issuing warrants on those at all. If in fact you are released from custody on posting bonds, those cases will remain active and you can come to court on those. But I'm not going to issue warrants because I don't need to unnecessarily burden the system with warrants.
Just as these ones currently are, because I was in custody when you issued the warrants.
That's not actually true. You were not in custody on March 11th. I issued those warrants, those cash or surety bond warrants, on March 11th.
Then why would you release me on March 28th?
You were ultimately released I think you were taken, not released, but taken to Jefferson County.
No, I was released. I was released.
Okay, then if you were released, then you were released on some kind of bond that you
I was
posted,
released
right?
on a PR bail on these charges, which is why I was asking you to please redo that, because the only reason I didn't show up was because I got arrested by Glenwood Springs or Garfield County and then transported to Jefferson County. That seems I was in custody by another jail after being released on PR bond on all these same ones. And
I hear what you are. I hear what you are arguing. It is not. It's incumbent on the defendant to appear in court on their court date. There can be all kinds of explanations for why someone doesn't appear, but it's not the court's responsibility to simply say, well, because you got arrested by another jurisdiction, you're exempt from having to appear in our court. You had an obligation to appear and you did not appear.
I tried to, they wouldn't bring me. There's nothing I can do about that.
Right. Well, right now, I'm maintaining those cash bonds in place. There won't be any other warrants issued on the other cases.
Okay, well, I'm going to go, and I don't mean to interrupt you, sir, but I have to. I'm going to just go ahead and say right now here on record, I'm appearing especially, not generally, and without a verified injured party and without proof of your assumed jurisdiction under administrative legislative statutes and or color of the law, you are violating my constitutional rights according to 42 USC 1983. And if you do not dismiss this case and you continue forward, I will be suing all of you in individual and official capacity for violation and knowingly depriving me of my constitutional rights under the color of the law.
Okay.
If you want to settle it, I'm down to settle it. I'm not.
You can't talk to me about settlement with me present. You can talk to the prosecutor with your lawyer present for that, but I can't negotiate with you because I'm not on the other side of the case. That's between you and the prosecution.
You are the judge though, and you do have the jurisdictional ability and legislative power to dismiss this before getting sued under 42 USC 1983, which is
I'm not dismissing it, nor do I believe I actually have the authority to dismiss the case where there's probable cause for the charge.
All right.
So the authority to request dismissal comes from the prosecutor's office. Now, let's talk about procedural posture where we're at today. So, Ms. Talene, do you want to come back on Monday or do you want to come back on Wednesday? We can do it either way. It's up to you.
Mr. Cardona, what do you want to do?
I mean, Monday would obviously be the best. I'm also going to contact my other attorney, which is Catherine Spangler, to get the other court date moved up. I'm time served on the other one. I would be time served on this, or you guys can all get sued. I don't really care. But I would prefer Monday. That would be the best. But I also want to give you time. And I'm speaking like me. I'm not trying to be a hard ass. I don't care. I've been getting fucked from I've been getting screwed from every angle without just cause. I've learned a lot of my rights and I will be exercising them. But again, I would much rather not deal with the fight, just as I know you would like to not deal with the fight. If we could please come to some form of agreement of time served I've been in jail for 122 days for something I didn't do.
I'm going to pause now because I think you're having discussions I don't want to hear because I'm not legally allowed to hear them. So if we'll reset, let's reset for Monday.
Yeah, we can reset for Monday. And if I can't do anything on Monday, we'll just reset you again.
Right. So another question I have. So you said they're $500 cash, or if it's a surety, it's $500, right?
That's right.
And so then somebody has to pay a bondsman 10% of that?
That's up to the bonds person. I can't speak for them, but a lot of times they will allow less than the full amount in order to be responsible for the bond. But it's not something I can commit to.
How many of them? There's 5 of them, or
yes.
Okay, and what were you about to say, Ashley? Sorry.
Yes, usually bondsmen charge 10% of what the bond is.
Okay.
So, but yeah, that again, though, that's not something I can help you with because I'm your attorney. So you got to go through a bondsman.
Right. I'm just trying to make sure I know it. Because the jail here, if I posted my $2,000 one and I gave them $50 cash, they would be releasing me. So I'm just letting everybody know that.
Then talk to the jail about that. And if that's what they, if that's satisfies your bond, then, talk to the jail.
Okay, yeah, I just had it written down about an hour ago. So I just want to make sure that if I go pay these things that I'm not right. So I'm just trying to work with everybody and make a winning solution for everybody. All right.
Well, like I said, talk to the jail. They'll talk to you about how they could potentially get you bonded out. So, okay.
And let me just say that one of these bonds, 235211, is a $50 cash bond. So 4 of them are at a $300 surety bond. So that one has a different amount on it than the other 4. The other 4 are 200 cash. This one's 50.
Okay. So yeah,
the jail has all of these bonds, so they know what the warrants are and what the bond amounts are. Whatever they determine for you to post to be released, they will do that and accept the payments from you as they deem appropriate, given the documentation that we've given to them.
According to them, less than an hour ago, those 4 $200 ones.
So just go talk to the jail about it then and see what you can do because
they shut up, stop.
Yeah.
All right.
I'm just saying they have the information. There's nothing else that Judge Khan can do for you. Now it seems like it's going to be between you and the jail and potentially a bondsman.
That's right. Okay. Right. We'll see you.
And we'll see you on Monday. Yeah.
What time do you guys know?
10:30.
Okay. All right. Thank you. Have a great weekend, everybody.
See you Monday.
Mia, please work with Look,
I'll talk
lady,
to Ms.
I'm not
Keller,
about.
okay? I'll talk to
I'm
Ms.
done
Keller
resisting.
about it.
Another thing I wanted to say is I've been a difficult prick a little bit in the past. I was going through a lot, and please work with me. And
I will speak with Ms. Keller, okay?
okay.
All
Thank
right.
you.
All right. Let the officer know that we're ready to go.
Bye, Con.
All right. Take care.
You too.
Fernanda, why don't you come on back? We can talk about how we reset all these cases.
Sounds good, Judge.
Well, guys, we've come to the end of this proceeding. And as we can see, Mr. Julio, Mr. Cardona definitely had his sovereign citizen head on. He talked about the injured party, no injured party. He talked about jurisdiction. He also talked about, and this was my first time hearing this, the color of law, where he said that they were doing illegal practices. And because of that, he said that he's going to be bringing a federal lawsuit to the courtroom and all those that were involved. One thing I will say is, as soon as stuff didn't go the way that he thought it would go, they stopped being friends immediately, because in the beginning, everybody was laughing. He was laughing. He was so happy to see them. But as soon as things didn't go as planned, or that little threat that he made didn't cause Judge Khan to, change his mind or intervene, or, overstep what the prosecution, had in their case or what they planned on doing, he just kind of went, full blown sob sit, or full blown angry, as we see. But, Judge Khan, as far as how he handled the courtroom, I felt like he did his job well, but he seems to be a lot more laid back than a lot of the other judges that we cover. Because even when Mr. Julio, kept swearing, Judge Khan warned him in the beginning, but, he swore a couple more times, and Judge Khan really didn't say anything about it. But, nonetheless, Mr. Cardona definitely had his super sovereign citizen head on. I'm interested in seeing what happens with the rest of this case. Looks like they probably will, find a way to figure this out. He doesn't seem like he's a bad guy. It seems like they're familiar with him, and, hopefully everything works out for him. But with that being said, as always, guys, I am appreciative of you guys joining me here on Sovereign Citizens Hall of Fame. Don't forget to like, share, subscribe, comment, as always. And with that being said, guys, this is Sovereign Citizens Court. And for now, Sovereign Citizens Court is adjourned. I'll see you guys soon, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.